Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business, where we're going to talk about one thing that you should always notice when you're looking at a contract. If you're new to All Up in Your Business, welcome. Please be sure to subscribe if you haven't already done so, and click that little bell so you get notified anytime I post a new video. And a quick legal disclaimer, while I am a lawyer, I am not your lawyer. The stuff I talk about in this video or any of my videos shouldn't be taken as a substitute for legal advice. If you need legal help, you should always consult with a lawyer who's licensed in your state. Don't just rely on free stuff you find on the internet. And since we're talking contracts in this episode, I want to make sure to mention that you can get all of your contract needs taken care of by visiting the CEO Legal Loft. My friend Michelle Murphy has put together a huge library of fantastically written contract templates that you can use in your business. I have personally reviewed and approved a lot of her contracts, and I know that they are very well written. So if you're in need of some more budget-friendly contract solutions, then definitely check out the CEO Legal Loft. You can find an affiliate link for it in the description. All right, so this is the third installment in my little mini series that I've called Huh? Because of course, that's what I find myself saying often when I'm reviewing or reading contracts, staring at them going, huh? What does this say? What is this trying to say? I had this with one of my clients just this past week. I was reviewing a contract from some other company that this client was going to maybe work for or work with, and man, I was saying huh a lot while I was reading that contract because it was bad. So anyway, welcome to Huh, where we're going to talk about notice clauses. The notice clause is one of these boilerplate contract clauses that we typically see kind of towards the end of a contract, and one that's often kind of ironically, it goes unnoticed. But basically, a notice clause is a contractual provision that we usually see in a contract that dictates how the parties to the contract can send and receive notice to the other party regarding some contractual obligations or something that they have to do under the contract. So in what instances and how do we send and receive notice to the other party? This might seem like a weird thing to put into a contract. Why do we have to specify notice, how I notify the other party of something? Well, because like everything else with contracts and business and law in general, things are open to interpretation. And if we say, hey, no, I notified you of this, and the other party says, well, no, you didn't. I didn't get the notification, or no, you didn't. We don't want to have to fight about notice or whether something was sent or received properly. And so we put these provisions in the contracts to avoid those kinds of issues of, well, was this notice properly given? And basically, when we abide by the steps in this notice provision, we can rely and know that when we're giving notice under the terms of this provision, it will be considered notice and it will be effective and valid under the contract. These notice clauses are always going to look a little different. They're not written the same in every contract, and we don't always see them in a contract. It's pretty common to see some kind of notice clause in a contract, but it's not always going to be there. The most important instances or kind of transactions where we really want to make sure there's a notice provision or some clause addressing notice in the contract. Typically, if there are some contractual obligations that have to be performed by a specific time, we might put a notice provision in there because of that. Sometimes the performance of contractual obligations might be contingent upon receiving some kind of notice from the other party or maybe even from a third party. So if one of our obligations is contingent or dependent upon receiving notice, then certainly we want to know, what does notice mean? Or if there's something in the contract that requires some kind of reporting to the other party, maybe about like the progress of the performance, whatever it is we're doing under the contract. If it's a situation where that might arise, then that's another instance where having a notice provision is going to be pretty important. So like I said, they come in different shapes and sizes. Here's what a kind of basic notice clause might read like or might look like. I'm going to read it straight from my computer because I don't have these things memorized, obviously, you guys. So a very basic notice provision might say each party shall deliver notices, requests, consents, claims, demands, waivers, and other communications under this agreement, each a notice. So we are defining the term notice here. That's an important thing. In writing and addressed to the other party at the addresses set forth on the first page of this agreement or to such other address that the receiving party might designate. Each party should deliver all notices by personal delivery, nationally recognized overnight courier with all fees prepaid, facsimile or email. That's a fax. For those of you who are younger than me, fax is a thing we sometimes still use, or email with confirmation of transmission, certified or registered mail with return receipt requested, postage prepaid, except as otherwise provided. Notice is effective only upon receipt by the receiving party, and if the party giving notice has complied with the requirements of this section. So there we have a pretty basic clause saying what is notice actually, and when is notice going to be considered received and effective. Only if we send it by hand delivery, overnight email, fax, or email, and at what date after that is the notice effective. So that's a simple version, but they can get a bit more complex or a little bit more complicated. Here's a more detailed example of a notice provision. Each party shall deliver all notices in writing and addressed to the other party at the address below. Delivery by personal delivery, nationally recognized overnight courier, certified or registered mail, facsimile or email. And then we actually set out the addresses of the parties. Maybe we ask that they send a copy to the legal counsel for the other party if they're sending notice. Sometimes it can go into great detail of if it's sent by overnight courier, then receipt is the day that it's received. Or if it's sent by email, then it's considered received within 3 days. All of these things can be kind of tailored depending on the situation. But the important thing is that we are aware, we notice what this notice clause is saying, because that's going to tell us how we notify the other party and how the other party notifies us of really anything. For common businesses and common instances of where this is really important, most often in my experience, we want to pay attention to notice when it comes to term and termination of the contract as well. So the term clause in a contract is basically how long is this contract going to last? Something that is kind of common in a contract term is that it will say this contract will have a term of 1 year. So our contractual obligations will be good for 1 year. This contract will automatically renew for 1-year terms unless a party terminates with 30 days notice. So basically, this contract has a year-long term, but it'll automatically renew for another year unless one party notifies the other of their intent to not renew with at least 30 days before the renewal of the contract. And so if our notice clause says that notice has to be sent by certified or registered mail, if there's not that email or fax section in there, then we can't just send an email to the other party saying, hey, I don't want to renew, let's terminate. We have to follow that notice provision and provide notice how it dictates and follow that. Otherwise, it doesn't count. And same thing with termination clauses. This is kind of important. Maybe if you're in a subscription, maybe, subscription services are all the rage these days. Everyone's got a subscription box or a subscription this, a subscription that. And typically the terms and conditions or the contract concerning these subscriptions will say, this automatically renews every 30 days. But if you want to cancel or terminate, you have to give 30 days written notice to terminate. Otherwise, it keeps renewing. And again, that's where we want to know, what does notice mean? Does that mean I can just text somebody at this other company and say, hey, cancel my account? Usually not. At a minimum, notice almost always has to be in writing. So you can't just, whisper, hey, I'm going to terminate this contract, or you can't call the other party and give them notice that way. Typically, it has to at least be in writing. So the overall takeaway from this, number one, that notice clauses come in a lot of different forms. They're not always standard. They're not always exactly the same, but they are super important, and they can have an important bearing on how the process of carrying out this contract goes, and if one party has certain obligations that they have to notify the other party of, or if we want to get out of this eventually, we have to know how to notify the other party of that. So even though this is one of those boilerplate provisions that we see in every contract practically, that doesn't mean it's something to be ignored or something that isn't important and won't really have an impact. It is important, and you should always notice and pay attention to the notice clause in your contracts, or if contracts are being given to you to sign or to review. That's all for this episode, folks. If you learned a thing or two, go ahead and give me a thumbs up. And of course, don't forget to subscribe and click that little bell so you get notified when I post a new video. Check the description for links to additional information and resources, including a link to check out the CEO Legal Loft if you need some well-drafted, lawyer-drafted, and lawyer-approved contracts for your business. If you want to keep this contract party going, and who wouldn't, I've got another video in my series talking about choice of law clauses, which are also a very important clause that should not go unnoticed. But anyway, you can check that out here, and I will meet you over there. Thanks for watching. I'm Aiden Durham, and I'll see you next time.